Good morning, good afternoon, and good evening to all you folks out there. Thank you so much for joining in. I'm Nipasa Pradhan on Immigration and Jobs Talk Show, and I'm very excited to have you on this webinar with us today. But before we proceed, I got this important disclaimer to start off with that I need to read out. And that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, welcome to Immigration and Jobs Talk Show, and welcome to this webinar that we are going to have today. It's going to be a very interesting one. I mean, if you look at the topic, the title today, it is already very interesting. Your client is dead. Now what? And it's going to be an attorney's guide to deal with all that you're going to probably face if this is happening to you, if your client is dead. Well, friends, thank you for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and Twitter. And remember, wherever you've joined us, if you have any immigration or job related questions, especially that is keeping in mind, with the title topic today, very much feel free to drop them in the comments because we have our expert who's going to join us once again after a real long time. I mean, after a hiatus, she had taken a break. So please help me welcome her back to the show once again. None other than attorney Seema Singh, and she is here with us. Welcome back, Seema. She is general counsel, attorney at law at Monmouth Junction, practicing in New Jersey right now. So welcome back, Seema. Thank you for joining us today.
Thank you, Nipasa, for inviting me back. And it's a pleasure to be here as always. And good evening, good afternoon, whatever the time is, wherever, to all the viewers. And, thank you for giving me this platform, this opportunity to, impart what I have learned in my legal career.
Really looking forward for this very insightful session, this webinar we're going to have today for an hour or so. So thank you once again. And it's really good to have you back and back stronger. I can see. So good to see you smile, and you're really looking very lovely today.
Thank you. Thank you so much. It's nice to be back after a long period of time.
Yes, I'm sure it must have been very busy for you, hectic with family and work.
Well,
Tell
I
us
had a
how has it
tragic
been?
loss in my family, and that's why the topic, your client is dead.
Right,
The
right.
topic follows from what
Sorry
I
about
just
your loss.
personally went through. So, but thank you.
Thank you, ma'am. Thank you. So, folks out there, you can expect a lot from here. Good things, absolutely. So, Seema, could you maybe give a sneak peek to the audience? What can they expect from our webinar today?
Well, what happens in the case of a death of a person, how you probate the will. If there's no will, what are the intestate laws? And I'm going to strictly, adhere to New Jersey laws when I speak. So I just need the viewers to be very clear. Each state in the US has different laws. So we are just focused on New Jersey law today. And, how does it affect their assets, their debts? What happens, in the event there is dispute between other beneficiaries? What are the tax implications, et cetera, et cetera. And we'll, take questions as we go along in this topic.
Doing this today. And without further ado, I think I'm going to just go ahead and start off with the first question that I got for you, Seema. And that is, if a client has passed away following a violent incident, such as an assassination attempt on a public figure, what legal considerations should be aware of regarding estate and liability issues? I mean, should one be aware of?
So if a person has committed a crime and subsequently passed away, and there are legal lawsuits against this person, it automatically transfers to the estate of that individual. And at that point, whatever the estate owns, so for example, if there are damages for injury to someone who was hurt by the person who's deceased, all that translates to his or her estate. So the estate at that point will continue to fight the case on behalf of the deceased. And whatever, whether they win or lose, that translates to all the assets or that are contained in the estate.
Mhm. Okay, very interesting. And of course, you'll have to see how violent the incident was, depending on the case, I think, depending on the situation, I'm sure.
Well, obviously, the person can't be incarcerated anymore. They are dead. So at that point, to the person who is the victim, the only recourse left is money. And let's hope that he had a big estate to at least compensate the person, or there are
Mhm.
insurance policies in place that can compensate them. And if there isn't, I've never had a situation, but they're out of luck, because what that person has done, only they can compensate you. If they've died, they have nothing in their estate, then that's your bad luck.
Mhm. Right, right. And well, do you have any interesting cases or case study that you would like to share in short, maybe?
Well, I've just had an incident like a couple weeks ago. My client had filed for divorce, and I found out a month later because I was trying to contact her, and she had passed away. I just found out like last week she passed away, and I was like devastated. I've never had this situation happen. So at that
Mm,
point, I had to go hunting around. I went on Facebook, tried to get the next of kin who was
mhm.
responsible. And for an attorney, once your client passes away, obviously you're not representing that client anymore because they have passed. But at that point, whoever the executor or the administrator is needs to take on that case and bring it to fruition. A lot of time, the other spouse thinks that if the person has died in the middle of the divorce, they get all their assets, but that's not the case. The divorce continues, and everything, the distributive share, goes into the estate of the deceased, and then it's divided to the beneficiaries of the estate. So the husband still has to, do the equitable distribution. Obviously, there's no alimony anymore because the person has passed away, uh, and the share goes into the estate. So, the divorce continues against the husband on behalf of the estate of the decedent, and the distributive share goes into the estate. So I'm working
Oh,
on that right
interesting, complicated at the same time. I mean, the person doesn't even exist to give him a divorce anymore. How do you go through this? But of course,
now. I
you're
mean,
only
the husband
fighting.
called me yelling and screaming that, oh, she's dead, you need to dismiss the divorce. And I'm like, no, you don't get all her money. He's been literally wiping out all her accounts thinking he is the surviving spouse, but he's an ex-spouse because on the date of filing of the divorce, there's no
He has
relation.
lost.
He's lost
Right,
that.
exactly.
So that's what's
Exactly.
happening.
Very
That's a
interesting.
very interesting case that just happened last week. And my client passed
Very,
away June 8th, and I find out a month later.
and I'm sure you would want to give in your all to fight for her right, for his right.
If I have the authority to do so, I need to first be retained by the executor or the administrator as the attorney for the estate. That's the only way
Mm,
one can fight for her. But
mm,
definitely, I'm creating a lot of hue and cry about it so that the court makes sure someone is appointed, because the husband was an abuser and he was,
mhm.
having adulterous conduct behind her back. So he shouldn't get her estate, the child or whoever's surviving her, other than the ex should get, the
Absolutely.
share of her estate.
Absolutely. Plus, she signed for a divorce, so that clears it all.
Right.
Let me quickly say hi to our audience. Thank you, Akbar, Neha, Sarika, Sanjeet, Mehna. Thank you for joining us and your questions and for cheering us. Thank you so much. Keep commenting and keep asking your questions. We are definitely going to come to each one of you. All right. So moving on, Seema, I have this next question. Only learning of a client's death, especially if they are ongoing legal matters, what immediate actions should you take? I mean, as an attorney also, since let's talk from both the point of views,
I
if
mean, I
there are
just
attorneys
answered that.
watching
My
us.
client just passed
Yes.
away, and the first thing I
Mhm,
did was try and find who is surviving her, who the
mhm.
beneficiaries are, because she died intestate. She had no will. So if you have a will,
Absolutely.
it's easy because everything is determined in that. However, even
Mhm,
at that point, your client is dead, so they're not your client anymore. The estate becomes a client of whoever the administrator or the executor hires. So that's the step I'm at, trying to find out who's going to be
mhm.
representing the executor or the administrator. And then at that
All right.
point, uh, you know, whoever the family members are, they need to go probate the will. That's the next step. You go to
Mhm,
the surrogate's office. If there is a will, if there isn't, you get an administrator appointed if it's intestate. and then you get letters administration issued with which you can take assets and start moving it into the estate account. So that's the general course. And if
Mhm,
there's a will, it's
mhm.
easy because a will is defining who gets what, who is the executor, and who has to be appointed.
Absolutely. All right. So I think let's move on to the next question now that I got for you. And um, suppose, how does the death of a client affect pending immigration petitions, if there are any? And what steps should you take to navigate these circumstances?
So, if a person who is deceased had filed an immigration petition on behalf of their relatives or their spouses, I know pre October 2009, those would be totally gone, eliminated, revoked, it's over. But now
Long
there's a
back.
new INA 2041 Act that they passed, in which they're at the discretion again of the USCIS. If you meet certain criteria, then they can reinstate your petition and let you get the green card and the citizenship. So that's a new law. There are, I mean, I don't have it at my fingertips, but there are many requisites. First of all, you have to be living in the United States when the person died, when
Mhm,
whoever's petitioned you, and you have to continue show an intent to continue to live in the United States. And then there are a whole lot of other criteria that you have to fulfill and convince the USCIS to not revoke that petition and to deport you. You have to convince them, and it's at their discretion, but they are pretty good at trying to reinstate and not revoke that. But pre 2009, it was automatically revoked. So that's the good
okay.
news for people whose petitions have been applied for.
Right, right.
And if
Thank
a
you.
person who's petitioned you as a citizen, then it's even better. You get your green card or citizenship, based upon again those criteria that you were in the United States, you're going to continue to live, and those are easier though. If the spouse was a citizen who had petitioned a non-citizen, a non-resident, um,
Mhm.
to move to the United States, but they have to be living in the United States at the time of the filing of the petition.
Okay, so no matter whatever pending petition, if it is already signed, I mean, the petition is already signed, the process is still on. They'll still get it.
No, it's revoked till you make that application and write to the USCIS
Okay,
informing them that this person has
all right.
died and
Has
to
died. Okay.
reinstate that petition, and to continue with the process of giving you the green card or whatever you've applied for. Even in
All
the
right.
case of even when a petitioner has filed for your green card and you get the green card and they immediately pass away, it's revoked
Mhm.
because it's a 2-year green card. Remember, you have to renew
Renew
it
it.
at 2 years. So immediately after the death, you should inform the USCIS so that they can reinstate that petition. Even when an I-130 is filed or a 485 is filed, again, that adjustment of status is again dependent upon this new act. And if you show them why it should continue, then it will. Otherwise, it's revoked.
Absolutely. And
So you
they
have
should
to take
always be
that added
informed. The
step.
latest update. Yes.
Exactly.
Right. Thank you. Thank you for taking that up. All right, let's move on now to the next question that I got for you. And these are about the critical steps. What critical steps must you follow to administer a deceased client's estate? And how might recent changes in probate law impact this process?
So again, like I said, as soon as somebody passes away, the you have to go to the surrogate's office to get the will probated or to get letters of administration if there is no will, and you have to wait for 11 days. That can only be done after the 11th day. And when you go to the surrogate's office, there are documents you need to bring with you. If there is a will, then you bring the original will, you take the death certificate, the original death certificate, the list of names of all the beneficiaries and heirs under the intestacy, obviously a check to pay the fees, and there has to be a bond posted. However, a lot of times if there's a will, they waive a bond because they are mentioning who the executor will be, and you take a list of the assets and debts. You may not have all of that when you go to the surrogate's office because sometimes if there's no will, you don't have that. And in the absence of a will, obviously you can't take a will. So you just go
Mhm.
without a will, but you take the death certificate. list of who the heirs are, and then the state law determines, you know, class A beneficiaries, class B, class C beneficiaries. So those are the ones then have can be made the administrator, and you have to obviously
Okay.
prove all of that. In New Jersey,
Okay.
what's interesting is if the will is self-proving, it's much easier
Hmm.
to probate it. And a self-proving will is you have two witnesses and they say that they're 18 years of old, sound mind, all that language has to be in the will. If it's not a
Okay.
self-proving will, then the probate will go and find the witnesses to, talk to them and make sure that that was a correct will. So
Right. Right.
when you're doing a will drafting, attorneys, we make sure that it's self, especially in New Jersey, you need two witnesses,
Hmm.
and that language of acknowledgement is extremely
Right.
important. Um,
Right.
so basically, once you get the letters testamentary and you get the executive shot certificate, you can go ahead and then send it to the banks and institutions,
Hmm.
and you can start, you know, moving assets. You have to create an estate account. You can't just move those
Okay.
into your account. And as the
Hmm.
deceased estate account is created, and then one by one,
Right.
all the assets go in there, and then it's distributed. In New Jersey,
Right.
you don't have to do a final accounting. It's not that monitored, but I know in many states you have to uh, submit a final accounting after the probate of the estate is done.
Okay. Okay. What if the will is like a normal will, so handwritten, maybe not in front of an attorney, but very personalized will? What about
I
those
mean, you
kinds?
can take that will as long as there are nobody who's coming to dispute, or you have to have a notice of renunciation sent and a notice sent out to all the existing heirs and beneficiary, and nobody comes and disputes
Beneficiaries?
it, then it's fine. But if there is a
Hmm.
dispute, then it goes into a whole different surrogates court, and Superior Court of New Jersey will go
Mm,
fight the lawsuit and let the judge determine who gets the distribution.
right. Right. Thank you for taking that up, Seema. All right. So, anything interesting as we go out through these questions? Maybe if there are some very interesting case studies that come to your mind. I mean, as that you have dealt with, these cases that you've done before. You can always share them. I'm just telling you.
Sure.
All right. Let's move on now. Then about now this next question. When managing sensitive information related to a deceased client, how can you ensure compliance with ethical standards and privacy laws?
It's pretty tough because a person is deceased and you know more information than the family knows. So,
Right.
discretionarily, you have to let them know that this is what she wanted, this is what her
Mhm.
desires were, without, and if, they have like a fatal illness, I'm not even sure how to handle that. I just don't share it because, I mean, the law is pretty gray in that area because the person is gone, right? So, privacy of a
Right.
dead person, um, I'm not sure how that pans out. I've never had that incident till this case that just came up. And there were a lot of issues that had happened with the husband that the family was not aware of, that,
Was
I
not
learned
aware of.
through
Yes.
her representation, which I had to share with uh, her, close family members to make them understand what the what the client actually wanted. So
Must be
there's
very
a
hard. Like,
law.
yeah.
And if,
Uh,
especially if there's a fraudulent act that you know about, those are not protected by any kind of privacy or privilege laws. If you knew that
okay.
there was an intent of your client to do some fraudulent act or do something wrongful, then those are
Hmm.
not protected by any privacy laws. You have to sort of disclose that for the higher public interest.
Hmm. But other private things like the relationship of your client, whichever, I mean, extra things that probably you can't even go tell the family. What do you
No,
do in situations? You just don't tell them at all. And
I would
probably,
tell them if it is affecting her, like for example, affecting her estate, and there's wrong information being given by the ex to, for example, say the child or to someone else. Then yes, at that
right.
point, I'll have to address it with the court first before I tell the administrator, because they may not,
Okay.
especially if a child is an administrator in a divorce case, especially, what do you do?
Hmm. And you can't go and directly speak with the child or the administrator at all.
Um, I have sent messages. If they speak to us, then that's fine. If they don't and they
Mm-hmm.
have an attorney for the estate, then obviously I'll
Oh,
speak to the attorney and pass all of the case to them to take care of it.
hmm. Right, right. But you will make sure that the important information is given out there so that
I
um,
try my
it goes
best.
the right way. Yes, goes the
uh,
right way. Oh,
Money is such a
all
bad
right.
thing. So when that comes into play, people go crazy.
I'm sure. I'm sure. I mean, money and also death, sudden deaths, when it all happens suddenly, and there's so much money or estate or property to be distributed. I'm sure the whole family goes
I mean, in
crazy.
this case, I know firsthand he started moving all her accounts. He used her death certificates, a letter testamentary given by the surrogate's office to start moving her assets. And I'm waiting for proof of all of that, which I haven't received yet.
It's tough. It's tough and crazy, and I
Yep.
don't know what to say. Ugly, also, how the world is, I guess. All right. Thank you for taking that up, Seema. Let's move on to this next question that I have. And if you can share any personal anecdotes or lessons learned from handling cases where the client passed away. This is your first, but what did you learn? Maybe you could give out a tip.
Well, then my tip is now make sure you talk to every client and say, what happens if you die in the middle of the case? Who is going to be administrator? Make sure that they know about me because it took them,
Right.
the family, a month to find me. They didn't know who was
Hmm.
representing her in the divorce. She had just told them, I have an attorney in Princeton. And they were like, okay, who is this person in Princeton? And then I, got an email from the husband's attorney saying your client passed away a month later. So you need to make sure uh, that you discuss this with the client. That's the lesson I've learned. That discuss it with
True.
them, make sure that they have the right person who is going to, take over on their behalf if God forbid something happens to them. So that's the
Right.
biggest lesson I've learned because I've seen that in the absence of the client having appointed the most reliable person, their estate could go into the wrong hands and to people that they absolutely did not want to go, who could be in the list of the statutory inheritance, but they
Hmm.
she doesn't want to give it to
Don't
them,
deserve it.
right? Or
Absolutely.
they don't want them to have it,
They don't want to. Yes, that's the word, actually. Yes.
right?
Yeah, so I think you should make sure, definitely. I mean, folks out there who are watching us right now, if you have clients, no matter what walk of life you are in, if you have clients and they're going to be dealing with you for a long time now, I think you should always discuss what are you going to do if your client is dead, and maybe have a plan A and a plan B just in case to be safe, you know.
I
And
mean,
thank
I've
you so
never
much,
even
Seema, for this.
thought of that till this happened, and I'm like, wow, anything can happen to your client in the middle of a case, and then what?
Then what?
And
Right.
estate planning is very important. They should have a will. They should have everything, stated in that will. That in the middle of my case, if something happens, who's going to represent, who they want the attorney for their estate to be.
Absolutely. Absolutely. Thank you so much. All right, Seema, I think we should just take up one or two questions from our audience since they have been waiting, and we will get back to our questions also for sure. But at this moment, I think we should take one. So let's take this first one. This is from Sanjeet on YouTube, asking, what are the legal requirements for notifying the court and other relevant parties about a client's death?
The legal requirements, I'm not sure if there are any requirements, but yes, as soon as if I'm representing a client in the middle of the case, something happens to them, the first thing is to call the court and let them know. And then the second is to I mean, a relative relevant, what is it, relevant parties, yeah, obviously we'll notify them that this is what has happened and then speak to the relatives. So I'm not sure what the legal requirements are, but
Legal requirements,
I
maybe
mean, yeah,
documents that could support that your client is dead, maybe what legal, I mean,
I mean, the
documents
death
can be.
certificate is there. Any
Death
obituary
certificate.
would be there. Those are like, no
Yes,
brainers, right?
goes
You have
without
a death
saying.
certificate,
Uh-huh.
you send it to the court. They know the client is dead, and then the next step is who's going to represent the decedent's estate because the case continues.
Hmm.
For example, the divorce continues. Her share has to be distributed, whether I
Right.
do it or the decedent's
Anybody
estate
else?
hires someone else. Somebody has to do it
Hmm.
to get all that
Right.
money going into the estate account.
Absolutely. Sanjeet, I hope you got your answer. Thank you for your question. And if you want more clarification, you can always comment. We are here for some more time. All right. This next one is from Mehna, also on YouTube, asking, what are the main types of visas available for immigrants to Australia, and how can I determine which one I'm eligible for? This is out of the topic, but
I
you can always
have
take
no
it up.
idea. I have no idea what
No
are
idea.
available in Australia.
Yes, this is absolutely out of the topic, Mehna.
Totally
I
not.
think we will keep this up for some time later, or some other expert will reply. But thank you for your question, Mehna. Thank you for watching. And right now, we are actually discussing this topic. If your client is dead, now what? And we're having an attorney's guide by none other than attorney Seema Singh, General Counsel. And she's practicing right now from New Jersey in United States. So once again, thank you for your questions, by the way. All right, let's move on now to this next one. Simran, please help me understand how does the death of a family member or sponsor affect the character and health assessments required for immigration applications, and what additional documentation, or I think there's a continuation, or evidence may be required in such cases. Can the estate or executor of the deceased person's estate take over the immigration application process, and what legal and financial responsibilities
Okay,
do they
there's like
assume in this
like
role? Very
several
long.
questions in that, so they need to break it down.
Let's take the first one first. It's very hard to otherwise. All right. How does the death of a family member or sponsor affect the character and health assessment required for immigration applications?
So I don't understand what health assessment means, but I already
Exactly.
covered that when a family member who sponsored you passes away, there is the after October of 2009, the INA Act 2041 has a caveat that allows for, under the discretion of the USCIS, to reinstate that application. But if a family member
Mhm,
dies or a sponsor dies, that's an automatic revocation until you advise the USCIS of the death and petition them to continue with your application. So it is the
mhm,
person who has been sponsored, um, petitions the USCIS to continue with the application and needs to show them that they have fulfilled those requirements. Health
right.
assessments, I'm not sure what that means.
Me too. Me neither.
Does it
All
mean
right,
health?
let's move on. Yes, Simran, if you could be more clear about what you really need to know, it would be good to know. And these things we've already discussed. Even the second part of your question, which says what are the additional documentations or evidence, we've already discussed that. You can always rewind this very webinar and watch it out. As for the last bit of it, asking, can the estate or executor of the deceased person's estate take over the immigration application process? What do you think,
I
Seema?
already covered that. They have to petition, they
Yes.
have to, write to the USCIS, letting them know of the death
Mhm.
and, have them
Yeah.
reinstate that application. Um,
Legal, financial responsibilities,
well,
do they
legal and
assume in this
financial
role?
responsibilities, if the person dies, I'm not sure what they mean by legal and financial, but every
Hmm.
cost for their finances or debts or all comes out of the estate account. There's a list
Hmm.
of debts you have to pay before a distribution is made to
Hmm.
your beneficiaries. So that's the reason an estate account is established, so that you can pay all the funeral expenses, you can pay for any, judgments you have,
Hmm.
or any secured or unsecured debts. There's a whole list of debts that need to be paid off once the person passes away from their estate account. So I'm not sure if
Hmm.
that's what they're talking about. Um,
Yes, I think I'll just say, Simran, we are here for some more time. I hope you got your answer. But if not, we are here for some more time. You can always ask, what
Also,
you really need to know.
their medical
More
bills,
clarity.
if there are pending medical bills, because if they died in a hospital out of illness, those need to be paid off.
True.
Uh, so there's a whole list of, I know there's funeral expenses, cost of administration of the estate. If somebody is doing your estate, their time, you need to pay them. And there's a percentage in the New Jersey statute that they get paid if nothing is written in the will as to how much they should be
Hmm.
paid. um, and taxes, if there are debts and taxes that are pending, those need to
Yes.
be paid off from the estate account. So
Yes.
that's the
Thank
financial
you.
responsibility
Yes.
we're talking about.
I think so also. Yes. Thank you for adding that up, and very important things to keep in mind as well. So I think this would answer all of your questions, Simran. I'm also very sure about that. So there you go. You have it. Thank you. Thank you, Seema, for taking that up. And folks out there, if you have questions and maybe you would like to consult with Seema directly, about your case and tell her everything about your status, why don't you directly contact her? Her details are on the screen. You can call her on the number 609-454-3168. That's her number. Once again, I repeat, 609-454-3168. You can even email her, Seema at ssinghLaw.com. Seema, SEEMA, at SSINGHLAW.com. And don't forget to also visit her website, www.ssinghLaw.com. Thank you, Seema. We'll just go for a short break and we'll be back to discuss further on this topic, not anywhere else, but here on Immigration and Jobs Talk Show with me, Nipasa Pradhan.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hello and welcome back, everyone, to Immigration and Jobs Talk Show. This is Nipasa Pradhan today with attorney Seema Singh, all the way from New Jersey. Very glad to have you here, ma'am, once again. And this is the second half, by the way. We've already started the show half an hour back, and we have been discussing about your client is dead. Now what? And it's an attorney's guide with none other than Seema Singh, General Counsel, Attorney at Law, Monmouth Junction, New Jersey, United States. So, once again, welcome back, everyone. And thank you so much, Seema, once again for doing this. It's been very interesting so far. All right, let's move on now. I got another question to move on into this topic and dive deeper. If you can tell us, what legal challenges might you face in settling a deceased client's debts and liabilities, and how can you prioritize and address creditor claims effectively as an attorney now?
So I'm handling one very high net worth estate uh, of my client's husband who passed away, and it's been a challenge because she has no idea. There was no will. She has no idea how much and where he owned assets. He has many companies. So at that point, I hired an outside service to do an asset check or an asset investigation. And, with his social and different identifiers we had. And we came up with a list of many accounts that he held, many companies he held. So that has been like a maze. And then you have to go at it one by one. With banks, there's huge challenges because you first have to get an authority from the executor appointing, or the administrator appointing you as their attorney. And
Mhm.
that authority, you reach out to the banks will tell you L8 waivers and estate planning application. um, you fill those out, you send it in, you get the account balances, then again it starts going into the estate account. But when you have so many accounts, just reaching the banks, getting all this moved could take months. Then there are issues related to if there are pensions or social security. Those are held separately. Social security, you have to
Yes.
go and they give you the higher of the amount. You have to make that application. Um, the good part about social security, pensions, in life insurance, all of that doesn't need to be probated. They can go directly into the estate account or directly to a beneficiary if it's listed. Even POD
Mhm.
accounts, payable on death bank accounts, you don't need to go to
Mhm.
probate. You can transfer it directly to whoever is listed as the POD on that account. uh,
Okay.
for spouses who are joint bank accounts, again, no probate. You just, the spouse who's surviving takes it. But where it has to go into the estate, and then taxes have to be paid, especially if there are
Mhm.
companies that you own. This guy owns at least 7 companies, some in Delaware, some in
Wow.
New Jersey. So each one of them, we need to file and convert it and move it to the spouse's name because she's the surviving beneficiary.
Mhm.
Get all of that done, get resolutions done. So it's pretty detailed and involved. And then, finding out list of creditors. Again, with that asset and debt search, that company helped me, find out whether there were any. Fortunately, there were no debts, but we
Mhm.
had. I could actually get to the bottom of where his accounts were and to start getting that moved. It hasn't been done yet. It's taking me almost months to get it moved. So those are the challenges you face.
I'm sure.
So what I recommend to clients is do your estate planning, have a list of everything you have, make it easy for your surviving beneficiaries and heirs so that they're not running around. I faced
Right.
a personal situation when my father passed
Mhm.
away and they had moved from India. All of our assets were in India. They passed
Oh,
away here, they had stuff here. I had to fly to India and literally it was like a maze because there was
I'm
no will,
sure.
and it was a very, very tough process.
Mhm.
So
And
those are the
rules are
challenges.
different in every country,
Right,
everything, I'm sure.
exactly. So everybody in this day and age should have their estate planning done, have your will done, have a list of assets where they are. Don't keep your original will in the safety deposit box because who's going to find it after you're dead? Do not do that. It's a challenge. You have to get a court order. You have to get the surrogate to give you an order to go open those boxes, and you have to first of all know where it is. So anybody who's estate planning, I've done. I keep a copy of it. Obviously, I don't keep the original. I give it to the client. Tell them to tell few people where it sits, so that they're not running around at that time.
Words, Seema, words, seriously. And folks out there, you heard it. You have to make sure, and I think, yes, make it easier for your beneficiaries and whoever you will be leaving behind. I mean, touch wood, I hope nothing is as bad is going to happen ever, but you never know. And one day or another, we all leave. So why not plan it out properly and make it easier, please? Seriously.
There's no age to die anymore.
It can happen anytime, maybe as we're sitting and talking as well. Who knows? So you have to do it, especially if you are very rich, own 7 companies, just like the Seema's client here. So don't make it so complicated. Have a will, get it done properly, and yes, make it easier once again. Let's move on, Seema. Let's take this next one. And how should you approach, identifying and locating beneficiaries and what legal processes are involved in asset distribution to heirs?
So I don't think that's an attorney's role to it's not an attorney's role to locate the beneficiaries because when a loved one dies you have all the people around you. So
Yes.
it's whoever takes charge and goes and files with the surrogate. A lot of times in the interstate categories, the actual heir may not want to be an administrator. At that
Mhm,
point they may give it up to someone else. So for example, you die and you have a child. The child doesn't want to be the administrator, or you haven't named, you don't have a will, you die intestate, your child doesn't want to be the administrator. Then the next of
mhm,
kin, your sister or your sibling or your brother, but then they can take charge and be the administrator, but they have to have renunciations from the actual heirs saying we renounce the role of the administrator, this person can take
mhm.
charge and do the administration of the estate. So and then notices are sent out. to make sure that there's nobody else alive. I know there was a situation, and this was not with me, it was with another attorney, where um, the mother lived in India and the husband passed away, left a surviving spouse and kids. And over here, if there's a surviving mother and there's no will, the mother also is entitled to a share. So you have to make sure
Okay.
that, when you fill the form, if you say your mother is the decedent's mother was alive, then you need to make sure a
Hmm.
notice is sent to them that they can waive their share and let the others take it, or they get a share.
Right, right. So each person alive, whoever the client was related to, all the beneficiaries should be informed about it and be
Yes.
present. All right.
Not be present,
Uh,
but they need to be notified. And if
They
they
need to be
want,
notified. Yes,
right, they can then intervene and either dispute it, or send a letter, or whatever it is. And obviously, if
despite
you
their
don't hear from
decision.
them,
Hmm.
right.
All right. Okay. Thank you. Thank you for taking
But
that
in
up.
the presence of a will, and that's why, and will is very important. When there is a will, then the surviving spouse gets it all. If there was a surviving spouse and a child, the surviving spouse gets it. If there's
Gets it
a
all.
surviving spouse and children from another marriage, then a part will go to them. So it's very important to have a will where everything is defined, because otherwise
Defined properly.
you are prone to whatever the state laws require and how the
Mhm.
distribution should happen.
And suppose there are so many heirs and so many beneficiaries, and just suppose one of them doesn't want their bit of the share. Who will it next go to then? Suppose there are 10, maybe
Whoever
number
they want
three
to
and
give it to.
number seven. Yeah.
It's all determined by categories. I'll have to literally pull that out because there's a
Okay.
long list of it.
So there
There's
are
class A,
categories.
class C. Yeah, yeah. The statute defines. I'm trying to find it
Okay.
here somewhere. Um, so a class A is a father, mother, grandparents, husband, wife, child, or children of a decedent, adopted child or
Okay.
children, issue of any child, or legally adopted child of a decedent, mutually
Hmm.
acknowledged child and stepchild. These beneficiaries also don't have to pay any taxes. So these are the class A
Okay.
beneficiaries. Then class
All right.
B has been eliminated. Class C is brother or sister of decedent, wife or widow of a son of decedent, or husband or widower of a daughter. And then there's a class D, which is other transferees and distributees or beneficiaries. So these are it's by class as to how that is divided then.
Very interesting. And everything has to go by rule and law. So, friends, you have to
Right. If there
read
is no
more
will,
about it.
in the
Yes.
absence
Yes.
of a will. Yeah.
Mhm. But still, I would still give a shout out to everyone out there. No matter what you own, I mean, make a will so that it's easier for people you leave behind. Let them know of everything that you have. I know sometimes it may be hard, but I think at least even if you don't want to tell them about everything right away, but write it down properly and maybe let them know where where your will is, so that they
Exactly.
know where to find it when the time comes. All right, so let's move on now to the next question that I have for you, Seema. Um, when disputes arise among heirs and beneficiaries, what strategies can you implement to manage and resolve these conflicts effectively?
I've never had that situation ever, but as a litigator, which is my expertise, I would have a meeting and sit everybody down. Um, Actually, I did have a situation where I was appointed as the attorney for a charitable organization that had inherited money from one of their devotees who was
Hmm.
who had no children, no husband, no nothing, and these were millions of dollars. And that temple appointed me as their attorney to get their share because a large chunk of that was coming to them. And there was a lot of dispute among the temple people as to how to use that money. And I had to put my foot down because the devotee had precisely mentioned in detail as to what that money was to be used for and how by the
Mm.
charity. So she had wanted mobile ambulances made to
Yes.
service the poor people. Uh,
Hmm.
that's what her money was to go to, and that's how the temple was to use it. But they wanted to use it by land in California, And I had to step in and say, but that's not what her will says. So there was a
Right.
major dispute. We had to sit all, I had a meeting of all of them, literally had to hash it piece by piece, and then we came to some kind of a middle ground as to how that needs to be used so that her wish is fulfilled as well. She even left
Absolutely.
$10,000 to her parrot. I remember that.
I swear,
Had
corruption
a
is everywhere.
parrot
It doesn't
for
even leave a temple, so
$10,000.
what can you expect?
So,
So,
you at that point, what I feel is, and it also depends. I mean, if you're an attorney hired by the estate and there are beneficiaries
mm,
fighting, you can't really talk to them. Hopefully, they have attorneys that you can sit and, mediate it and try and settle it. If not, it goes to
mhm.
court, it's tried, and then the judge makes a decision based upon the laws. I mean, that's a strategy I would have
Very
employed
interesting.
for any kind of a dispute.
Hmm. Well, thank you. Thank you for sharing that. And I think at this moment we should take up a question. And this is from Oindrila. This is on YouTube. Seema, I think we'll just quickly take this up. I'm concerned about the impact of my loved ones passing on our pending green card application. Is there anything I can do to keep the application process moving forward despite their passing? Let's
If they've
answer this
passed,
first.
why
There's
do
a
you want them to have a
continuation.
green card? I'm confused with this question.
Me too, me too. But let's move on.
You've
There's a
applied for
continuation
someone's green
asking.
card who's passed away. They passed away. Why would their application remain pending? And maybe she meant the reverse.
Maybe, or maybe she is somebody who would be benefiting from the green card, maybe wife or something. Let's just find out. There's a continuation. Can I request to expedite to ensure that my application remains active and is not denied or closed due to their death? What are the necessary steps and documentation required to achieve this?
I don't do immigration law, so I don't know what the documentation is, but I do know that the Act, the INA Act 2041, allows you to get your application reinstated and get it expedited if you want. I'm sure there's a higher fee for that. But you should consult somebody who does in immigration. I don't do too much of immigration, but I do know that your application, if a deceased person has petitioned you, that gets revoked, but you can get it reinstated under that new act, which was passed after October 2009, the INA Act 2041. And that has several criteria that you have to meet for your application to remain active and to actually get the green card or citizenship as well.
All right, very interesting. And Andrela, maybe if you could tell us more, I mean, about the green card for a deceased person doesn't make so much sense, but tell us how are you probably related to your loved one, or are you, what is the question really? Please let us know. Let's move on now to Hannah's question, also on YouTube. If the deceased client was involved in legal proceedings that were unresolved at the time of death, what strategies can an attorney employ to protect the client's interests? I think we've already spoken
I've
about this.
already answered that, but I'll
Yes,
repeat it,
Hannah.
that the estate can
Sure.
continue with that lawsuit, and whoever the attorney for the estate is needs to take that on and continue it. I had a executor of an estate who hired me because his brother fell and was very injured on the head, and then he died in a week after that. So it was a wrongful death case, and the executor hired me for the estate of that individual. And we went after the landlord because of the way the premises were kept with a lot of ice. He hadn't cleared it, which was his obligation under the lease. And then
Mhm,
eventually the insurance company of the landlord paid the
mhm,
estate like a few $1 million that we got. So the executor hired me to represent the estate of his brother who had passed away.
mhm. Oh,
So you
I
can keep it
mean,
alive.
very unfortunate, the situation.
Mhm.
Sorry, you were saying something? I
No, that's it.
interrupt.
That's the answer to it.
Yeah, thank
Estate
you, thank you. And sorry?
the estate can continue with the legal lawsuit or the legal disputes that are pending at the time of the person's demise.
Right, right. Well, this leads me to the question I have for you, and that is, what role does life insurance play in estate planning, and how should you navigate insurance claims after a client's death?
Again, the same way. You have your letters testamentary, you have the letters from the surrogate's office, the certificate of death. Life insurance policies are easy because you already have a beneficiary named. So it doesn't need to go to probate at all. You can just call them, they'll take all the proofs and identifications and they'll just transfer it to your account. Those are the easiest, actually.
Easiest. Okay.
Yeah, because you have to name a beneficiary on your insurance policy. So those just get,
Hmm.
and they're exempt from taxes, by the way. You don't pay
Okay.
tax on that.
Okay. Okay, moving on. This next one is a little bit related to immigration, but see if you would like to take this. For non-citizen clients, what special considerations must you take into account regarding their family immigration status and potential avenues for humanitarian reinstatement?
I already answered it. It's that INA Act.
The INA Act. All right.
Yeah.
Anyway, I think we are almost done, but we'll take up a couple more questions from the audience, if that's fine. So this is from Pavan. What should be done if the deceased client was the primary breadwinner and their family members are now at risk of being deported due to the loss of their immigration status?
So if there is already a petition filed, I already covered that. The INA Act, you need to petition them, show them that you meet the prerequisites and get that reinstated. So there will not be a deportation. But if your person who was deceased and all of you are all illegal in the country, then you just remain illegal the way you've been staying here. So I'm not sure
Mhm,
actually what the status of the primary breadwinner was,
mhm,
or is. That, how would they be at a risk to be deported? If there's an application pending, you have a recourse. If all of them were illegal, then you just continue till somebody finds you and deports you. I mean, I know it sounds harsh, but that's a reality, right?
that's the
For
truth,
pending
yes.
applications, there's an act that actually protects you if you meet the
Mhm,
requirements.
right. Well, there is a continuation from Pavan. Number one is, how will the family members' immigration policy be
The same
affected by the client's death? Same answer. Will they able to continue their application or will it be terminated? Same answer. All right. Thank
It's
you. Pavan, I think
automatically
we've answered your
terminated. It's
question.
automatically terminated and revoked. You need to make sure that it's reinstated. And there is that law that allows you, that act that allows you to meet the
Mhm.
requisites and get it reinstated.
There you go, Pavan. You have it. And I'll ask you, do you need an attorney? Yes, you do need an attorney. They will guide you on the right path. So why don't you, consult an expert? An attorney would be great. And if you want to also consult with none other than Seema Singh, you can always contact her. Her details are scrolling on the screen. Moving on, I got another question now. This one is from Mir. I'm wondering, how should relationships with third parties, example, business, partners, creditors, be handled after a client's death? And what is the procedure for substituting parties in ongoing litigation? Where in ongoing litigation where the client has passed away.
So is the client a member of the company? I mean, if the
The
client
third
is part
party.
of the
Yes.
business, and again, your partnership agreement, your shareholder agreement should be written in such a way that it takes care of what happens in the event of one person's demise. And as far as the partnership or the company goes, it should have that section as to how that is taken care of, and whether the deceased person's family can take their place, or they have to sell his shares or liquidate or evaluate. That needs to be taken into account. Again, all of that goes into the estate of the deceased, which is being monitored by the executor or administrator. And I'm not sure what do you mean by what is the procedure for substituting parties in ongoing litigation? What kind of litigation? And who has passed away? If the client has passed away, again, the estate gets substituted in if that litigation needs to continue. And again, you need to
Yes.
know who the executor is, administrator is, who they want to hire as the attorney. If they want to get someone else, then you need to do a substitution of attorney. If they want to continue with you, they need to retain you as the administrator, executor of the estate.
True, true. Every case is different, and each detail has to be kept in mind for each case. So, friends, I think I will always say, it's always best to really consult your attorney. And if you don't have one, you can always reach out to Seema Singh as well. Her details are scrolling on the screen. Well, Seema, I was wondering if you would like to share any case study, anything interesting
I've
that you
shared
have
so
been
many.
maybe going through.
I've
Yes, you
shared so
already did
many with you
actually.
already. I've shared at least four of them already.
But it's so interesting, to get to know about these. Oh, well, anyway, moving on. What best practices can you adopt, when managing cases involving deceased clients to ensure professional conduct, while supporting grieving families? Any tips?
I mean, talking to them, communicating with them, assuring them, showing them the legal processes they can take to protect their loved one's estate, if they're not aware of it already, sort of guiding them to, what are the steps to take to protect it. I mean, at the end of the day, the person is gone. All you can do is make sure that you give them solace in the fact that, how to navigate through the process of, probating their estate, how to get the assets and debts together. Those are the kind of support that you can basically offer as an attorney. um, I mean, I don't,
Yes, that answers it. That answers it. Thank you so much, Seema, for
because
clearing
your
that up.
client was
And
not the family, the client is deceased now. So
mhm.
all you can do is, give them solace. And if you have a will in place and they don't know about it, the best thing is to present them with the will of your client, saying, okay, by the way, there was a will. That could be the best present to give them if they're not aware of it.
Yes, absolutely. Thank you so much, Seema. I think we have covered most of our questions and under this topic, whatever we could discuss. So I'm sure viewers out there got ideas or at least know what should they do, especially if they own a lot of property, estate, and uh, companies. Maybe you really would like to distribute them well. So get a will done and do it on time and be ready for anything that may come.
And if it's
Well,
high net
Seema,
worth, I would suggest getting trusts done. A qualified, domestic trust is equally important if you're a non-citizen and your spouse was a citizen who passed away, because you're going to pay high taxes on it. So those are other implications, the tax implications of, not being a citizen. When your spouse who was a citizen passes away, you are prone to higher estate taxes at the federal level, like 40%. And so if you convert that into a trust and it goes automatically to a trust, then your spouse who's a non-citizen will not get that higher estate tax. So these are a lot of things that one should sit with an attorney who does estate planning and, plan the estate in a way that your loved ones are not subjected to all these taxes at the end. Find out what their immigration status is, guide them as to, how to create their estate plan, where the money should move after their demise, so that the taxes are minimized. Because New Jersey
mm,
has estate and inheritance tax. So inheritance taxes are paid by the beneficiaries, and then there is also estate tax at the federal level. So these are the things that one needs to keep in mind.
absolutely. Thank you so much, Seema, for guiding us throughout today. This whole webinar was very insightful, interesting, with all your cases added. Thank you so much also to all the audience. Very interesting questions. But Seema, before we go, maybe if you could leave our audience and us with a short message or a tip, whatever you wish, or maybe you could talk about the latest assassination attempt, anything you want to talk about, but very
Oh my
short
God.
and sweet
I'd
to
rather
end.
not touch that topic. I mean, it's sad to think of it. Nobody should go
Sure,
through
but
that.
an end note would be
And,
great.
but
Yeah.
that's another example of why we need to plan our estate, because you could be walking on the road and somebody hits you and goes. So it's age is no bar to death, is what I would say. So everybody should be planned and plan so that your loved ones can benefit from your hard work, your accumulation of wealth, and it just doesn't go in flames once you pass away because you worked hard at it. Make sure your beneficiaries are settled; they don't go through a lot of trouble in trying to get what they should get and what you want them to get. Um, so plan your estate. There's no harm. Some people say, "Oh, I'm not going to die." Well, we all are going to die. but when, we don't know. So better be planned. Better safe than sorry. So, good luck to all of
Very
you. If
well
I can
said.
help, please contact me. And, thank you, Nipasa, for allowing me this opportunity to impart whatever I've learned through my almost 30 years of
Experience.
law practice.
Thank you so much, Seema. I just cannot thank you enough. And it's really good to have you back. So I'm looking forward
Thank
to
you.
seeing you more often, maybe,
Thank you.
hopefully next week again.
No, thanks a lot. And
Thank you.
also,
Thank
I
you,
just
Seema, for
became a
joining in.
grandmother, so I'm very happy about that. I have a beautiful and
Congratulations.
handsome young 6-month-old grandson, and
How
that's been the
nice.
biggest joy, the best promotion I could ever get. So,
Lovely, lovely. Congratulations,
thank you.
really. And may he grow to be a very handsome and, well, it's good. It's really going to be great to
And
see you with both of
thank
you. Thank you. Thank you for
thank
doing
you,
this once again.
Nipasa.
Have a
Thank
great day.
Yeah. Bye bye.
Bye bye. Thank you, folks, for joining us today. It was really lovely having each one of you and your questions. Though we couldn't maybe touch up on all of your questions, we will have our experts answer them. So thank you for your questions once again. And for those of you who got your answers, I hope you resonated, and I hope that you don't forget to like, share, and subscribe to our channel. Our handle is Immigration and Jobs Talk Show. We are on YouTube, LinkedIn, Facebook, and Twitter. I'm Nipasa Pradhan. I'm also there on LinkedIn. You can connect with me. It'll be really good to connect, and anything related to immigration or jobs, feel free to connect with us. You can also contact me. My details are on the screen. You can WhatsApp me on this number or even call me 408-335-6444. And my email address is neep@higheritpeople.com. And if you're looking for project placement, TN, green cards, anything related to visas, immigration, feel free to connect with us. And also don't forget to check out our website. Our website is www.higheritpeople.com. Thank you for joining us today, and bye bye for now. Have a great day. This is Nipasa Pradhan signing off from Immigration and Jobs Talk Show.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nepa@higheritpeople.com or visit our